This is CPD Tap by NTI, and we have a very special moment today because following the case in the Supreme Court on Friday, that's Friday the 4th of August, which caused a degree of consternation, it being about litigation funders, we at NTI are so glad to have an absolute expert with us. This is Mena Halton, who is Managing Director of Manolete Partners. Mena is also a solicitor. And as you know, because Manolete are partners of in many events with NTI, and they are the leading providers of finance for insolvency litigation. Of course, you already know that. Mena is head of Manolete's legal team of, I think, 16 lawyers. So, and I have spoken to Mena about this before. Trust me, she absolutely gets it and knows what she's talking about. So, Mena, a very, very warm welcome to NTI's CPD Tab.
Thank you, Neil. Thank you very much for that introduction. I hope I can be of some assistance in getting some information out there on how all this impacts on the world of insolvency.
Yeah, I'm sure you will do. I'm absolutely sure you will do. So, I mean, I'm, with all due regard, I'm going to just jump straight into it because everybody is really keen to know. And there've been quite a lot of articles out there, but nothing I've seen has been as clear as your explanation to me on Friday. So I'm going to ask you a very simple, immediate question, which is, what actually did the Supreme Court decide in PACCAR?
Right. So in PACCAR, the Supreme Court was concerned with a funding agreement entered into by two companies called Yarcombe and Therium, and that was in connection with a class action in the Competition Appeals Tribunal. And to enable them to obtain a collective proceedings order from the CAT, the respondents to the appeal, so that's the funded parties, they needed to show that they had adequate funding arrangements in place to meet their own costs and adverse costs should they lose. And they relied on the litigation funding agreements with Yarcombe and Therium in an effort to meet those requirements. And the CAT held that the funding agreements did not involve the provision of claims management services and therefore were not damages-based agreements. And the Divisional Court dismissed the appeal. The appeal then went by the leapfrog procedure directly to the Supreme Court. And the Supreme Court held that the provision of financial services does constitute claims management services, and the litigation funding agreements were damages-based agreements, which will be unenforceable unless they comply with the damages-based agreement regulations 2013. And it was agreed by the parties in PACCAR that the Yarcombe and Therium litigation funding agreements were not compliant with the DBA regulations, therefore unenforceable.
So, and I'm getting a sense of it was because of the way they were structured. That's why they were unenforceable. So, can I then ask you the follow-on questions? So, in your view and massive experience, how does the decision impact on third-party finance in insolvency litigation?
Well, in terms of insolvency litigation, the decision has a minimal impact. And this is because claims, for the most part in insolvency, are capable of assignment. So funding agreements are much less of a feature than in litigation by solvent parties. And a claim or a cause of action is property within the meaning of section 4361 of the Insolvency Act. And a claim or cause of action is an asset to be realised for the benefit of the creditors, just like any other asset, like plant, machinery, stock, real property. And an IP's power to assign that cause of action is contained in the Insolvency Act at Schedule 4, Para 6 for a liquidator, Schedule 1, Para 2 for an administrator, Schedule 5, Para 9 for a trustee in bankruptcy, and Section 246ZD of the Insolvency Act extended the power to assign to office holder claims in liquidation or administration from the 1st of October 2015. So the antecedent transaction claims such as preference, transaction at undervalue, wrongful trading, they're also capable of assignment in corporate insolvencies. And generally, the need to fund rather than assign arises in connection with office holder claims in bankruptcy, which can't be assigned. So the PACCAR decision is not concerned with purchase agreements, because under a purchase agreement, the claim is advanced by the assignee as claimant or applicant. And to put this in context, as we speak, Manolete has 397 current purchase agreements and only 21 current funding agreements. So the funding agreement is very, very much in the minority.
That's interesting. So, and that's really clear to me, and I hope it's clear to our listeners. So in your view, then, Mena, what is the impact on historic completed funding agreements, which have already been entered into by insolvency practitioners?
Yeah, that's a good question, Neil, and I know this is something that people have been talking about and wondering about. Again, the answer is the decision has minimal impact, if any. If a funding agreement is unenforceable because it doesn't comply with the DBA regulations, that doesn't render the agreement void. The effect of Section 58AA2 of the Courts and Legal Services Act 1990 is to render a non-compliant DBA unenforceable, not void. It remains a valid agreement. And historic completed funding agreements have been performed. And it wouldn't be in the interest of creditors for an IP to seek a remedy in unjust enrichment based on unjust factors of failure of basis or mistake, as such an application is most unlikely to succeed. On a completed case, the obligations have already been performed without either party having had to enforce them, and the payments made under the agreement were made voluntarily on the basis of the agreed obligations. The IP has taken the benefit of the funding and received the proceeds and possibly distributed pursuant to an agreement freely entered into at a time when both parties to the agreement believed it to be enforceable. The court expects an IP to act fairly, and there is a long line of authority on this going back to the rule in Ex parte James in 1874. On the other side of the coin, there are completed funded cases which have not resulted in recovery, and Manolete has sustained losses in own and adverse costs, and we will certainly not be seeking to claw back those costs.
I think that 1874 case was the very first one I reported on this on CBD Tap, so I did it live as well. But Mena, that was so clear. I tell you why, so I've been seeing so much of a buzz on the web, and also people are looking to this. They seem to be fumbling around trying to find a meaning to all this, and that was the clearest explanation I've ever heard. So I'm sure that everybody else is thinking the same way and are heaving great sighs of relief. So I've actually only got one final question, really. So it's a typical kind of interviewer question, which is, probably makes you shrink when you're going to hear it. But in your view, what is the way forward for financing insolvency litigation? So if I saw that case and I kind of either ignored it or I read something and I'm not sure about it, but I have, say, a wrongful trading case that is bubbling away, or maybe something on preference or misfeasance, and I am an insolvency practitioner in England and Wales, what should I be doing? What is the way forward from now in terms of financing that level of and that type of litigation?
Well, I hope I can provide some reassurance to the insolvency profession. And really, it's very simple. Insolvency claims will continue to be assigned for value under purchase agreements. In the small number of cases where the claim cannot be assigned, Manolete will amend the terms of our funding agreements to comply with the DBA regulations. So in conclusion, very much business as usual.
If you know something, I'm going to heave a sigh of relief on behalf of all of my fellow practitioners in our glorious sector. But Mena, that is firstly, it's incredibly reassuring. So thank you for that. But secondly, it's also incredibly useful. So I'm so delighted you spent some time with us today. And I am sure there'll be many people listening to this CBD Tap webcast who will also be very grateful to you. So thank you and for your colleagues at Manolete, as always, for saving our skins and showing us the way. And I'm sure you and I will be talking again. But for now, on behalf of everyone at CBD Tap, Mena, thank you so very much. It's been an absolute pleasure talking to you, and it gives us enormous amounts of, it gives us food for thought, but also a great deal of sense of relief too. So thank you very much indeed.
Thank you, Neil.